I be fired for taking a second job outside of work? Imagine this. You're working full-time, but bills are piling up. Maybe rent went up, gas costs more, or you just want extra income for your family. So you pick up a second job, a weekend shift at a store, driving Uber at night, or freelancing online. Then your boss at your main job finds out and says, "You're fired. We don't allow second jobs." You're stunned. You wonder, is this legal? Can my employer really fire me for taking a second job outside of work? This is a growing issue in America. With wages stretched thin, millions of workers juggle multiple jobs. But employers often see second jobs as conflicts of interest or threats to loyalty. The law is complicated here. At-will employment gives employers broad discretion, but there are limits when discrimination, retaliation, or state laws come into play. In this video, we'll explain when employers can fire you for moonlighting, when they cannot, and how workers can protect themselves. Imagine this. You're working full-time, but bills are piling up. Maybe rent went up, gas costs more, or you just want extra income for your family. So you pick up a second job, a weekend shift at a store, driving Uber at night, or freelancing online. Then your boss at your main job finds out and says, "You're fired. We don't allow second jobs." You're stunned. You wonder, is this legal? Can my employer really fire me for taking a second job outside of work? This is a growing issue in America. With wages stretched thin, millions of workers juggle multiple jobs. But employers often see second jobs as conflicts of interest or threats to loyalty. The law is complicated here. At-will employment gives employers broad discretion. But there are limits when discrimination, retaliation, or state laws come into play. In this video, we'll explain when employers can fire you for moonlighting, when they cannot, and how workers can protect themselves. At-will employment, the default rule. In most states, at-will employment applies. That means your employer can fire you at any time, for almost any reason, including having a second job. Unless you're protected by a contract, union agreement, or state-specific law, there is no blanket right to hold two jobs. Example, a bank teller takes a part-time bartending job on weekends. The bank fires her, citing outside employment policy. Under at-will rules, that's legal. Employer concerns about second jobs. Employers often cite several reasons for restricting second jobs. Conflict of interest. Working for a competitor may risk confidential information. Performance concerns. Fatigue from extra hours could affect productivity. Availability. Employers want flexibility for overtime or changing schedules. Reputation. Employers may not want employees associated with certain industries. Many companies put moonlighting policies in their handbooks, requiring disclosure or even outright banning outside employment. Example: a tech company prohibits employees from freelancing for competitors. An engineer who secretly does side work for a rival risks termination. State laws on lawful off-duty conduct. Some states provide protections for what workers do outside of work, as long as it's lawful. These laws vary. California protects employees from being fired for lawful off-duty conduct, including second jobs, unless there's a conflict of interest. Colorado prohibits employers from firing workers for lawful off-duty activities, again unless it interferes with business. New York protects legal recreational activities off-duty, which may include outside work. North Dakota offers broad protections for lawful activity outside work hours. Example: a worker in Colorado holds a weekend catering job. The primary employer tries to fire her simply because of moonlighting. She may challenge the termination under state law. When second jobs are protected by federal law. Certain federal laws indirectly protect workers with second jobs. NLRA protects collective activity. If workers take second jobs as part of organizing or concerted action about unfair wages, retaliation may be unlawful. FMLA. While on approved leave, employers cannot retaliate against workers for lawful off-duty activity, though abusing leave may create problems. ADA. If a worker needs a second job because their disability accommodations are not met at the primary job, firing them might raise discrimination claims. Example: a worker discusses taking a second job with coworkers as part of a broader conversation about low wages. Firing her could violate the NLRA because the discussion was protected concerted activity. Conflicts of interest and non-compete clauses. One clear area where employers can restrict second jobs is conflict of interest. If your second job competes directly with your primary employer, termination is usually lawful. Many contracts include non-compete clauses or conflict of interest policies. While non-compete agreements are being challenged in many states, they still play a role in restricting outside employment. Example: a sales associate for a cell phone company also works for a rival carrier. The primary employer can fire them for conflict of interest, even in states with off-duty protections. Unions and collective bargaining agreements. Union contracts may address moonlighting. Some agreements allow second jobs, while others restrict them. Unionized workers generally have just cause protections, meaning an employer must prove the second job harmed business. Example: a unionized nurse works per diem at another hospital. Her main hospital fires her. If the union contract allows outside work, the termination may be overturned in arbitration. Real-world cases. Case 1. A Colorado worker fired for bartending on weekends challenged the termination under lawful off-duty conduct protections. The court sided with the worker. Case 2. A California employee terminated for delivering food on weekends filed a complaint. The labor commissioner found no conflict of interest and ruled in his favor. Case 3. A bank teller in Texas fired for working a second retail job had no claim because Texas has no off-duty conduct law and at-will rules applied. Case 4. A nurse in New York fired for doing part-time home care work successfully argued that it was a lawful off-duty activity under state law. These examples highlight how outcomes depend heavily on where you live and what your contract says. What about gig economy work? Today, many workers take on gig economy roles, driving for Uber, delivering for DoorDash, freelancing online. Some employers tolerate this, others don't. Again, it depends on policy and state law. Example: a retail worker in California drives for Lyft at night. His employer tries to fire him. Without a conflict of interest, California law may protect him. In Texas, the same firing would likely be legal. Deductions and scheduling conflicts. Even if taking a second job is lawful, problems can arise. Employers may schedule mandatory overtime, conflicting with your second job. Refusing overtime can sometimes lead to discipline. If performance drops, employers may cite the second job as the reason for termination. If company property or resources are used for outside work, that can lead to lawful termination. Example: an office worker uses her company laptop for freelance work. Even if moonlighting is allowed, misusing employer property may justify firing. Practical steps for workers. 1. Check state law. Do you live in a state with lawful off-duty conduct protections? 2. Review your contract and handbook. Look for moonlighting or conflict of interest clauses. 3. Avoid conflicts of interest. Don't work for competitors or use company resources. 4. Keep performance strong. Don't let fatigue from a second job hurt your primary job performance. 5. Document retaliation. If you're fired after discussing low wages or union activity, that may be illegal retaliation. 6. Seek legal advice. If you're fired and believe your second job was lawful, consult an employment attorney. Example: a cashier fired for working a second job at a clothing store challenges the termination. If state law protects off-duty conduct, she may win reinstatement or damages. The human impact. Many Americans rely on second jobs to survive. Being fired for moonlighting feels like punishment for trying to make ends meet. Workers often feel trapped. One job doesn't pay enough, but a second job risks their first job. This tension shows how wage issues and employer policies collide in modern work life. The bigger picture. At-will employment gives employers wide power to restrict second jobs. But federal laws, state laws, and contracts create important exceptions. Workers in states like California and Colorado have stronger protections. Those in at-will states like Texas may have little recourse. Ultimately, the right to work a second job depends on balancing employer interests with worker survival. So, can your employer fire you for taking a second job outside of work? In most of the U.S., the answer is yes. At-will employment allows it. But there are exceptions. Federal laws protect against retaliation and discrimination. States like California, Colorado, New York, and North Dakota protect lawful off-duty conduct. Union contracts may require just cause, and conflicts of interest almost always justify termination. The bottom line: taking a second job can be risky, but your rights depend on where you live and what agreements you've signed. If this video clarified your rights, share it with coworkers. In today's economy, many of us need more than one job, and knowing the legal landscape makes all the difference.